Hello and welcome to this podcasted lecture on administration of trusts. This is the penultimate topic area for equity in trusts, but ties in very closely with the final topic area around breach, liability and remedies. Taken together, these two topic areas give us an overview of what it takes to be a trustee, what's involved with being a trustee, and what the consequences are of failing to act in accordance with the expectations of what is required of trustees. It will soon become obvious how onerous the office of trusteeship actually is. Legal title without the equitable title is by no means a privilege. Equity imposes many duties upon a trustee which, unless these are relaxed by the trust instrument, must all be discharged with diligence and professionalism. We'll be looking at the general obligations which are owed by trustees unless something is provided to the contrary in the trust instrument. Trusts, as we know, are equity's most utilised invention. And we know from earlier in the course that equity is said to act on the conscience of the legal owner of property. The office of trustee is in truth an example of that concept. We've encountered some of the personal obligations incumbent on a trustee in relation to a beneficiary, in part when we discussed enforcement of trusts in relation to constitution and covenants to settle. We'll be focusing on the nature of a number of obligations specifically to do with the responsibility of the trustees to communicate information to the beneficiaries and the manner in which trustees are required to carry out their duties. We'll also be considering the more general nature of trusteeship, including a number of administrative matters such as appointment, retirement, removal and control of trustees, as well as some powers associated with the office of trustee. Some general points and observations to note before we proceed. The distinction has to be made between a trustee's duties and his powers, and this is an important point to remind ourselves of that distinction. A duty is an obligation which must be carried out. Equity requires strict performance of a trustee's duties, and these are imperative in nature. Power, on the other hand, as we know, is discretionary. It's a mere permission. It can be exercised, but then again, it doesn't necessarily have to be exercised. And this is true of both powers given by statute or those contained in the trust instruments. In terms of the number of trustees, there's no restriction on the number of trustees of personalty on establishment of the trust. In the case of land, any receipt for capital money has to be given by two trustees or a trust corporation if the interests under a trust are going to be overreached. So there's no point in appointing a single individual as trustee to such a trust, as a second one would only have to be appointed anyway if the land was sold. With regard to a maximum, there was a suggestion that whatever type of property is involved, the trust should be limited to four for later appointments. But for land, there already is a statutory maximum, as can be seen on the slide. And this applies both to the establishment of the trust and to subsequent appointments, so it's a maximum of 4. If there is more than one trustee, then all trustees are required to be active in the management of the trust. Equity doesn't allow for so-called sleeping trustees, and trustees of private trusts have to act unanimously and not by majority vote, unless this is expressly authorised in the trust instrument. A majority decision doesn't bind a dissenting minority nor the trust estate. The restrictions on numbers of trustees and the requirement for unanimity. The first thing we're going to look at in any detail is how a trustee comes into office. How a trustee is appointed. Who can be a trustee? Can you refuse to be a trustee? How do you appoint replacement trustees? Can you add more trustees? Who decides? Who cares, you might ask? Well, the answers to those questions are coming. As to why we're looking at the mechanisms for appointment, though, the answer to that is quite simple. If a mistake is made in this very practical area of trust law, the consequences can be quite disastrous. In the case of Jasmine Trustees and Wells and Hines in 2007, the High Court illustrated that point amply for us. Here there was an action for professional negligence against various solicitors firms arising from a 1982 deed of appointments and retirement of trustees that appointed a Mr Thornton and a trust company to act as new trustees. Now, the new trustees were based in the Isle of Man, and that was the problem. In 1982, trustees could retire provided that the trustees they left behind were at least 2 humans or 1 trust corporation. Unfortunately, in this case, the retiring trustees left behind 1 human and 1 trust company, which, because it was incorporated outside of the European Union, couldn't be regarded as a trust corporation. The retirement of the trustees, therefore, had been invalid, and the retired trustees, the people who thought they'd retired, in fact continued to be liable for all trust matters. Now, the knock-on effect of the new trustees being unaware of the fact that the trust was now invalid in the UK was to render any subsequent appointment of trustees void. Now, the trustees might have hoped that that would get them off the hook, but even though they were not true trustees, as in being recognised officially as express trustees, they continued to be liable to the trust as trustees de son tort, i.e. a trustee of their own wrong, and they were liable to pay tax on the trust. So they could, conceivably, have been required to account for 2 decades of wrongfully received remuneration, plus compound interest, and without any hope of relief from liability, because they wouldn't have had any of the defences that are available to true trustees open to them. So the lesson really from that case is never to accept the appointment as trustee without first checking that all trustees have been correctly appointed and or retired in past. So this is really why it's important to know the technical provisions as to how you appoint and how you retire a trustee. But who may be a trustee? Well, in principle, anyone who can hold a legal title to property can be a trustee of that property, whether it's of realty or of personalty. But Section 20 of the Law of Property Act makes the appointment of a minor in relation to trusts void automatically. There are a number of special types of trustee listed on the slide, all of which really are beyond the scope of our syllabus. But in terms of who in practice acts as a trustee, then members of the family of the testator may consent to be trustees out of feelings of duty or loyalty to the testator or settler. And these non-professionals will usually then employ professional agents such as solicitors and accountants to perform the technical duties of the trust. It is common, however, to appoint a mixture of professional and non-professional trustees. In general, trustees can't expect any remuneration for carrying out the job itself, so professional trustees, for example solicitors and insurance companies and so on, will only undertake the work where there is express provision made in the settlement or the will. In reality, most trusts of any size will have a professional trustee, maybe in conjunction with a family member. Given the onerous responsibilities which we're going to come on to discuss, does the law expect and require a person to act as trustee just because that's the settlor's intention? I.e., can a prospective trustee refuse to accept the office? Well, put simply, yes, a person may refuse to act as a trustee and is perfectly entitled to refuse the entire office from the outset, authority coming from Lord Talbot's judgment in Robinson and Pett. So nobody can be compelled to accept the office of trustee against their will. Any person who wants to disclaim the office of trustee should do so by deed, a formal disclaimer, as that provides clear evidence. But it is possible to imply a disclaimer with, say, for example, consistent apathy towards the management of the trust, providing the evidence of an intention to disclaim. Always better to do it formally, though. In the event that the office is declined, and also for a number of other circumstances, there are provisions for appointments of replacement and additional trustees in the Trustee Act 1925. In particular, settlors appoint the very first trustees, and so they could choose malleable people who will carry out the settler's every wish. For those who might remember Robert Maxwell, who disappeared over the side of his boat in the early 1990s, this is an example of such a situation. The choice of malleable people as trustees contributed substantially to the Maxwell pension scandal that erupted in the early 1990s. £420 million had been removed from the pension schemes of the Mirror Group newspapers, which was controlled by the late Maxwell. The trustees of the pension funds were employees of Robert Maxwell and were thus inclined to follow his orders. As a result, legislation in the form of the Pensions Act 1995, now amended by subsequent legislation, was passed so that now trustees of a pension scheme aren't exclusively chosen by the employer who creates the pension trust. Now pension trustees must usually include people appointed by members of the scheme. But once set up, the settlor can neither remove nor appoint new trustees unless the trust instrument provides to the contrary. Of course, the settlor may appoint himself as a trustee to try to influence the running. So, the first trustees will be appointed by the settlor in the trust instrument, but for later appointments there might be an express power contained in the deed, although this is incredibly rare. And instead, the settlor normally identifies who is to exercise the statutory powers of appointment, and these are contained in section 36 of the trust. So let's take a look at that section and the statutory powers of appointment. Section 36 of the Trustee Act 1925 provides where a trustee, either original or substituted, and whether appointed by a court or otherwise, is dead, or remains outside the UK for more than 12 months, or desires to be discharged from all or any of the trusts or powers reposed in or conferred on him, or refuses to act, or is unfit to act therein, or is incapable of acting therein, or is an infant, then the persons nominated in the deed for the purpose of appointing new trustees, or if there is no such person or no such person able and willing to act, then the surviving or continuing trustee or the personal representatives of the last surviving or continuing trustee may by writing appoint one or more other persons to be a trustee or trustees as replacement. So, as we can see, if the trust instrument nominates a person to exercise the Section 36 power, that person will make the appointments. If the trust instrument doesn't name such a person, or they refuse, or are unable to act for whatever reason, then the surviving or continuing trustees make the appointment. For example, say the first trustees appointed by the settlor were A and B, and A dies, B, as a surviving trustee, could make the appointment. If the only or the last trustee has died, that trustee's personal representatives can appoint new trustees under Section 36. For example, if we refer back to our A and B scenario from a moment ago, if B also died before appointing a replacement, B's personal representatives will appoint a new trustee or trustees. In the meantime, B's personal representatives have to run the trust. Therefore, there is an incentive for the personal representatives to make the new appointment as soon as possible. The term continuing trustee referred to on the slide and in the Act is defined in Section 36, subsection 8, saying that this includes a refusing or retiring trustee if willing to act in the execution of the provisions of this section. So, what we've just been considering there in relation to Section 36.1 is a situation where there are a number of existing trustees and where one becomes unable to continue as a trustee for a number of possible reasons. They might be leaving the country for an extended period, they might have died, and they might no longer be capable of acting physically or mentally, that they might just wish to retire. And Section 36 allows a replacement to be appointed under those circumstances. Now, there may also be situations in which a trust needs an extra trustee, either because of growth in the trust or because it lacks expertise in the current range of trustees that are available. So they might need to appoint a new professional trustee with particular skills or expertise. Section 36, subsection 6 permits the appointment of additional trustees in these circumstances, and the exercise of that power is done by the same people as who can appoint in Section 36.1. Plus, the court might also appoint under their inherent jurisdiction, and as authority for that, see the case of Re Tempest. Now, this inherent jurisdiction will only be exercised by the court if the conditions on the slide are satisfied. That is, that you can ascertain the wishes of the settlor, that it's done in the interests of all the beneficiaries, and that it's for the promotion of the carrying out. Under Section 36, the procedure for replacing trustees and appointing additional trustees is straightforward. The removal of a trustee and the appointment of trustees should be in writing. However, it is necessary for the old trustees to transfer all the trust assets to the people who will be trustees after the new appointment. To this end, a deed of appointment is desirable because, where the appointment's by deed, then advantage can be taken of Section 40 of the Trustee Act 1925, which vests most items of trust property automatically in the new trustees. There are a few minor exceptions. Most significantly for our purposes would be stocks and shares. These require the usual formalities of the stock transfer form and registration of the new trustees at the company. So we've seen that Section 36 puts the question of changing trustees firmly in the hands of the trustees themselves, in general, unless a trust instrument provides to the contrary. We'll now come to look at other mechanisms to secure the removal of trustees at the suit of the beneficiaries or the court. It is a feature of the paternalistic nature of a trust that trustees sometimes have to act against the wishes of the beneficiaries in the beneficiaries' own interests. Generally, trustees can ignore the wishes of beneficiaries when they exercise their discretions. It's a mentality of it's for your own good. And it's these features of a trust that might have been what persuaded the settlor to create a trust in the first instance, rather than make an outright gift. But Section 19 of the Trust of Land and Appointment of Trustees Act 1996, commonly referred to as TOLATA, gives beneficiaries a power to direct the retirement of one or more trustees, saying that they are able to demand the appointment of a new trustee of their choosing, provided that reasonable arrangements have been made for the protection of the trustee's rights, and only if there is no person nominated for the purpose of appointing new trustees in the deed of trust, and only where all the beneficiaries act together and are sui juris, i.e. of full age and mental capacity. So Section 19 gives beneficiaries the power to replace trustees if the trustees don't obey their wishes. Does this not therefore undermine the nature of a trust to an extent, that paternalistic nature that was talked about a moment ago? There are in fact a number of ways in which it's possible to effect the retirement or removal of a trustee. An obvious but exceptionally rare method is through an express power in the trust instrument. We've already seen that Section 36 is used when a trustee wants to retire and is being replaced. If no replacement is being made, then Section 39 provides a general statutory power for this purpose. This section allows trustees to retire without the replacement if afterwards there will be either a trust corporation or two trustees left, as long as the retirement is effected by deed, and the other trustees and anyone having power to appoint new trustees consent by deed. But on the previous slide, we were thinking about where a trustee wants to retire. How about the forcible removal of trustees? Is this possible? Well, consider whether it's possible at the suit of various different people. In terms of by the beneficiaries, then if you remember our discussion on express trust, the rule in Saunders and Vautier gives beneficiaries some considerable strength, but it cannot be used to direct the retirement of a trustee as such. But of course, if they satisfy the requirements of that rule, the beneficiaries could, if they were all acting together, call for the trust property outright, therefore ending the trust, and then direct it to be held on new trusts by trustees of their choice. Also, Section 19 of TOLATA can, as we have seen, be used, but its application is limited. The court also has an inherent jurisdiction under which beneficiaries or trustees can apply to remove trustees. The removed trustee doesn't have to be replaced. There are no grounds for the application as such, but there are factors that influence the court in deciding whether or not to exercise its discretion, and it should only be where it's proper to do so in the interest of the beneficiaries and where it doesn't encourage capricious retirement. As well as the inherent jurisdiction of the court and the other mechanisms we've already seen, Section 41 of the Trustee Act provides that the court may appoint new trustees if it's expedient to do so, and it is otherwise inexpedient, difficult or impractical to do so without the court's assistance. The courts have exercised their discretion under this section where the donee of the statutory power under Section 36 couldn't exercise it, i.e. because they were infants or because they were abroad or incapable, etc. And the court can appoint new trustees under Section 41 as replacements or additional trustees, but they don't have the power to remove trustees without a replacement. Assistance of the court under Section 41 can be sought by the trustees where they're unable to appoint under Section 36 or by the beneficiaries themselves. So that's appointment, retirement, removal and replacement dealt with. Now we come on to look at the issue of controlling the trustees. To what extent is this possible? There are two key questions here, both contained on the slide. Can the beneficiaries compel trustees to carry out a particular act in the administration of the trust? And secondly, will the court interfere with the exercise of discretion or power by a trustee? In terms of compelling trustees to act, as noted at the start of the lecture, a distinction needs to be drawn between duties and powers. Duties must be discharged, whereas trustees need not exercise powers. They are a mere permission. Now, the beneficiaries can compel trustees to perform their duties if necessary by court action. In contrast, though, trustees are under no duty to exercise a power, and the beneficiaries cannot force them to do so. In other words, it is entirely at the trustees' own personal decision as to whether or not to exercise the power. But in two instances, the trustees are under a duty to act, but the way in which they exercise their duty is in their discretion. In these cases, the beneficiaries can insist that the trustees carry out their duty, but can't dictate how this should be done, because this is in the trustees' discretion. The first instance concerns investments, and trustees are under a duty to invest trust funds in authorised investments, that is generally profit-making investments, but the choice of authorised investments is in their discretion, so beneficiaries can't insist that trustees exercise their discretion in a particular way. As an example, Ralph and Titus are trustees of a large trust fund. They have left £20,000 of trust money in a non-interest bearing bank account, where it's clearly not making money for the trust and does not therefore constitute an authorised investment. And the trustees are therefore in breach of their duty to invest trust money in authorised investments. The beneficiaries want Ralph and Titus to invest the money in Blanco plc shares. Now, the beneficiaries here can force the trustees to invest the money in an authorised investment because that's a duty. They can also recover compensation for loss caused by the trustees' breach of duty so far. However, they cannot insist that the trustees invest in a particular type of investment. They can't insist that it goes in these shares in Blanco because the choice of investments is a discretion, and the beneficiaries cannot make trustees exercise their discretion in a particular way. The second instance of a duty combined with a discretion is a discretionary trust. A discretionary trust, as the word trust suggests, imposes a duty on the trustees to select an object or objects, but the question of whether they should select A as opposed to B is a discretion vested in the trustees. As an example, under a discretionary trust, the trustees Bill and Ben were given 10 years to distribute capital to the settlers' children. The 10 years have expired and no distribution has been made. One of the objects, Jack, is desperate for money. Here, Bill and Ben are in breach of their duty to select an object, and the objects can, of course, complain to the court. The court will ensure, then, that the duty is exercised in some way. For example, the court may order Bill and Ben to carry out their duty. However, the question of which beneficiary should be selected is a discretion, and Jack cannot insist that the trustees exercise their discretion in his favour. The trustees only have to consider him. We can conclude then that the beneficiaries can force trustees to perform duties whether they relate to administrative matters, such as investment and the day-to-day management of the trust, or to dispositive matters, such as distribution of trust funds amongst beneficiaries. However, they cannot compel trustees to exercise powers. Now, a duty may coexist with a discretion, as we've just seen with investment and discretionary trusts. A court order compelling the performance of the duty indirectly ensures that the discretion is exercised as well. However, the beneficiaries cannot insist that the discretion is exercised in a particular way. Continuing on the issue of control of trustees, let's assume now that the trustees exercise a discretion or power, but the beneficiaries don't like the outcome. Will the court interfere with the exercise of discretion or power? Some examples given on the slide. What's the position if the trustees have exercised the power of appointment and given trust money to an object called X, but the other objects of the power think that the trustees gave the money to the wrong person? Or what if the trustees have exercised their discretion under a discretionary trust in favour of W, but another object, Z, says he should have received the money instead? Let's consider the principle in Re Hastings Bass, which may have led the court to declare the exercise of a discretion a nullity. And 3 questions had to be asked by the courts when reviewing the exercise by trustees of their discretions. Firstly, what were the trustees under a duty to consider? Secondly, did they fail to consider it? And if so, what would they have done if they had considered it? So in essence, it would have to be shown that trustees failed to take account of all relevant considerations or took into account irrelevant considerations, and this led them to act in a different way than they would otherwise. Under this rule, it had to be clear that the trustee would not have done what they in fact did had they taken the proper issues into consideration, and it was not enough to show that the trustee would have realised that what they were doing was to some extent unsatisfactory. And that comes from Mr. Justice Warner in Metoy Pension Trustees and Evans and others in 1990. So the rule in Hastings-Bass would not allow trustees to escape inconvenient consequences of bad decisions in all cases. There were limits, but there were also areas of contention. And there had been suggestions that the rule in Hastings-Bass ought to be tightened because it cannot be right whenever trustees do something which they later regret and think they ought not to have done, they can say they never did it in the first place, from Mr. Justice Park in Bredner and Granville Grossman. Also see suggestions on similar lines in the Abacus Trust case. And the nature of the error required to prompt the court's intervention was also problematic. In Abacus, the judge rejected the proposition that the mistake had to be fundamental and said the rule would apply where the exercise of the discretion involved a breach of the trustee's duty to properly consider how to exercise the discretion. The principle known as the rule in Hastings-Bass, as developed from Metoy onwards, though, was considered not to be a correct statement of law. And in Pitt and Holt and another, and Futter, the Court of Appeal civil decision held that the rule was incorrect and promulgated a new rule. In cases where the acts concerned were within the powers of the trustees, but were said to be vitiated by the failure of the trustees to take into account a relevant factor to which they should have had regard, the principled and correct approach to these cases was first that the trustees' act was not void, but that it might be voidable. It would be voidable if and only if it could be shown to have been done in breach of fiduciary duty on the part of the trustees. If it was voidable, then it might be capable of being set aside at the suit of the beneficiary, but that would be subject to equitable defences and to the court's discretion. Fiscal considerations would often be among the relevant matters which ought to be taken into account. However, if the trustees had fulfilled their duty by seeking proper professional advice, they hadn't committed a breach of trust, even if the advice they sought was wrong. That concludes the first part of our podcasted lecture on administration of trusts. In the next part, we will begin to consider the duties of a trustee and the duties that they owe specifically to their beneficiaries. Hello and welcome to the second part of our podcasted lecture on administration of trusts. In the first part, we considered some general administrative matters such as how a trustee comes into the office, how they're appointed, how, if necessary, they are replaced, how they might be retired, and whether or not we can, to any extent, control the behaviour of a trustee. So we've started a little bit to touch on trustees' duties. Logically then, we should now consider these in a little bit more depth. And trustees have certain duties, some of which are fiduciary. These include the duty to carry out the express terms of the trust instrument, the duty to defend the trust, the duty to prudently invest trust assets, the duty of impartiality as amongst the beneficiaries, the duty to account for their actions and to keep them informed about the trust, a duty of loyalty, a duty not to delegate, a duty not to profit, the duty not to be in a conflict of interest position, and the duty to administer the trust in the best interest of the beneficiaries. These duties may be expanded or narrowed by the terms of the instruments creating the trust, but in most instances cannot be eliminated completely. A trustee carries the fiduciary responsibility and liability to use the trust assets according to the provisions of the trust instrument, and often regardless of their own or the beneficiary's wishes. The trustee may find himself liable to claimants, prospective beneficiaries or third parties. In the event that a trustee incurs liability in excess of the trust property they hold, they may find themselves personally liable for the excess. Trustees are generally held to a prudent person standard in regard to meeting their fiduciary responsibilities, though investments, legal and other professionals can be held to a higher standard commensurate with their higher expertise. Trustees can be paid for their time and trouble in performing their duties, but only if the trust specifically provides for payments or they're acting in a professional capacity. And it's common for lawyers to draft will trusts so as to permit such payments and to take office accordingly. But this could be an unnecessary expense for small estates. So we're going to start by looking at the duty of care and how that evolved through case law, before moving on to consider the codification of trustees' duties in statute, and then looking in a bit more detail about the fiduciary nature of trusteeship. Now, I said very early on that we discovered that trusteeship is an onerous office to hold. Let's start then with the common law to explore what was meant by this. What duties does a trustee owe to the beneficiaries? What exactly is the standard of care that's expected of trustees? Well, the classic statement of duty is to be found in the judgment of Sir George Jessel, Master of the Rolls in Spate and Gaunt, in the Court of Appeal. Gaunt was the trustee of Spate's will, and he employed a broker to invest £15,000 of the trust fund in local corporation bonds. And when the broker absconded with the money, the beneficiaries sought to make Gaunt liable for the loss. And Gaunt was ultimately held not to be liable by the Court of Appeal. And it was stated in the Court of Appeal that trustees must act honestly and ought to conduct the business of the trust, taking all those precautions with which an ordinary prudent man of business would conduct his own. And beyond that, there is no liability or obligation on the trustee. So a trustee is not bound to conduct business in anything other than the ordinary and usual way. And it could never be reasonable to make a trustee adopt further precautions than an ordinary prudent businessman. So Gaunt was ultimately held not to be liable on the basis that the appointment of a broker and his subsequent conduct had been that of any prudent man of business. I'll talk to you a little bit more about delegation in the next part of our podcasted lecture, but it was also explicitly acknowledged in this case that while delegation inevitably involves some element of risk, it was a practical necessity in any sort of contemporary trust administration. As Lord Justice Bowen said, a trustee could not do everything himself. He must make use of the arms, legs, eyes and hands of other persons, and the limit within which it seems to me he is confined is this, that a trustee may follow the ordinary course of business, providing he runs no needless risk in doing so. And when the case then went up to the House of Lords, Lord Blackburn set out the requirements regarding standards of care required by trustees and agreed entirely with the Court of Appeal. When making investments though, the trustee is subject to additional restrictions, as he mustn't take the same risks as a prudent man of business might be prepared to take with his own money. Lord Lindley stated the rule in Re Whiteley, saying the duty of a trustee is not to take such care only as a prudent man would take if he had only himself to consider. The duty rather is to take such care as an ordinary businessman would take if he was minded to make an investment for the benefit of other people for whom he felt morally bound to provide. Now, in the case itself, a trustee was held to account for imprudently investing £3,000 upon the mortgage of a brickworks. The land didn't offer sufficient security, and when the business failed, therefore the land couldn't be recouped. Now, it still may be a difficult test for a trustee to observe though, particularly if that trustee is not a professional investment advisor. As this concept was put by McGarry in Cowan and Scargill though, this duty includes the duty to seek advice on matters which the trustee does not understand, such as the making of investments, and on receiving that advice, to act with the same degree of prudence. The approach that's expected is that trustees are to focus primarily on the protection and maintenance of the trust fund whilst allowing it steadily to grow. We'll look at the statutory codification of this principle in a little while. Continuing with the common law duty of care, if a trustee is in a professional position, they're acting in a professional capacity, will there be a higher duty of care than is the case if a layperson is acting? Well, let's consider the case of Barclays Bank on the slide. Barclays Bank was the sole trustee of the Bartlett Trust, and the sole assets of the trust were shares amounting to almost all of the issued shares in the family company. In an attempt to raise cash, the trust appointed merchant bankers to consider taking the company public. The bankers advised that a public offering would be much more successful if the company expanded its business from simply managing property to developing property as well. Barclays Bank, as trustee, agreed to this policy, but the board of directors of the company then embarked on certain speculative developments, one of which ended in disaster when planning permission couldn't be obtained for a large development and the trust suffered a significant loss. Mr. Justice Brightman held that the bank, as trustee, hadn't discharged its duty as being a trustee, as it failed to supervise the new ventures of the company. And he held that given the size of the shareholding, the bank should have obtained the fullest information on the conduct of the business, and it wasn't sufficient to rely merely on the supply of information they received in the ordinary course of business as a shareholder. As a bank, they couldn't stand by and do nothing, and the bank would be liable for the losses incurred. As a paid or professional trustee, they should be held to a higher standard, the standard of skill and expertise that they would claim to possess. Having said that, in Nestlé and Westminster Bank, the Court of Appeal appeared to suggest that there was not a higher standard of care that applied to professional trustees, in that case also a bank. And the Law Commission, when looking at this area prior to the Trustee Act 2000, didn't feel the need to make the professional lay trustee distinction the subject of one of their recommendations. However, as we will see, statute has now clarified this area of law. Moving on then to consider how the duties have evolved to codified form in statute, our main point of reference is the Trustee Act 2000, which regulates the duties of trustees in English trust law. The Act covers 5 areas of trust law: the duty of care imposed on trustees, trustees' power of investment, the power to appoint nominees and agents, the power to acquire land, and the power to receive remuneration for work done as a trustee. It sets a new and clear duty of care, both objective and standard. It massively extends the trustees' power of investment and limits the trustees' liability for the actions of agents, also providing for their remuneration for work done in the course of. Lawyers and academics have been pushing for reform of this area of law since at least 1982, when the Law Commission published a report advising reform of the rules over trustees delegating their powers to other people. Other trust reform came about through Talata, but this didn't cover most of trust law. Although there were some other small changes, little else was done. And further papers were published on similar areas in 1997 and 1999. And finally, the Trustee Bill 2000 was introduced to the House of Lords in January 2000, implementing the proposals laid out in the Law Commission's 1999 report, Trustees' Powers and Duties, the Act being given royal assent on the 23rd of November of the same year and coming into force on the 1st of February in 2001. Now, in its consultation paper on trustees' duties, the Law Commission stated that the law governing the powers and duties of trustees has not kept pace with the evolving economic and social nature of trusts. Indeed, the default powers which trustees have under the present law are generally regarded as seriously restrictive. Before the Trustee Act 2000 was passed, the ability of trustees to delegate was severely restricted. This caused problems, particularly in the field of investments. Firstly, the trustees couldn't delegate discretions. They could ask agents for advice, and they could employ agents to execute a sale or purchase, but the actual decision on whether to sell and what to buy had to be taken by the trustees. The choice of trust investments was a discretion, and discretions couldn't be delegated. This approach was clearly out of step with modern investment practices. Investors often give their advisor wide powers, including the ability to decide to sell the investor's shares and buy others without the need to consult the investor. The second major restriction was the rule that the trust property could only be vested in the names of all the trustees. It was thought that there was less risk of the trust property being misappropriated if it remained in the hands of the trustees. However, it is quite common for substantial investors to transfer their investments to discretionary portfolio managers as nominees to hold on a bare trust for the investor. The bare trust ensures that the investor can demand the shares back at any time. And the purpose of the arrangement is to enable transactions to be carried out quickly so that valuable investment opportunities aren't lost. Transactions can be effected rapidly because the manager can deal with the shares without having to bother the investor at all. The manager can even sign the transfer forms because they've got legal title. Many investment advisors will only agree to act on this basis. Thus, it was felt that the old rule preventing trustees from entering into this arrangement deprive some trusts of good investment advice. So clearly the main aims of the Act were all connected with modernising the administration of the management of trusts by giving trustees more freedom when it came to delegating and investing. Looking in a little bit more detail then at the provisions of the Trustee Act 2000, Section 1 contains the duty of care and states that a trustee must exercise such care and skill as is reasonable in the circumstances, having regard in particular to any special knowledge or experience that he has or holds himself out as having, and if he acts as trustee in the course of business or profession, to any special knowledge or experience that it's reasonable to expect of a person acting in that kind of business or professions. Now, this duty of care applies when the trustee is carrying out his functions under the Act or any equivalent functions under the trust instrument, and it clearly takes into account the case law position as seen a few moments ago, with allowance being made for those who are essentially being paid to do the job. And it seems reasonable that a paid professional trustee, be he a solicitor or stockbroker, who's being paid to exercise certain skills, should indeed be in breach of trust if he doesn't exercise them. The position of the lay trustee, on the other hand, is often an enviable one. They can incur personal liability for acting innocently, but erroneously, and they're often acting for no reward. The common law standard of care from Spate and Gaunt is objective, and clearly not all lay trustees come up to this standard. The individual trustee simply may not have the knowledge of the reasonable man of business. But does the Act do anything to lower the standard of care required of them? Well, possibly not. The trustee is still required to show such skill as is reasonable in the circumstances. In considering whether this standard has been reached, it seems that all the circumstances of the trust will be considered, its composition and its purpose. The statutory duty takes effect in addition to any provisions under the Act and doesn't affect any other duties, e.g. the fiduciary duties, which we'll come on to consider in due course. Part 2 of the Act created a new power of investment. Historically, many trusts and will trusts were professionally created and granted wide powers of investment to the trustees. Older trusts, which include a number of charities, didn't grant such wide powers. It should be remembered that the majority of people die intestate, and this will in many instances create a trust. Under these provisions though, trustees without specific investment powers are able to invest in the same range of investments as the beneficial owner of the property. This includes lending money on mortgage, and this brings these trusts into line with most professionally drafted trust documents. The Act gives trustees the power to invest the trust fund as though they owned the asset personally and not on trust. So this will give them the power to hold investments jointly or in common with other people. The term investment itself isn't defined in the Act. However, the Act envisages that investments will be made in an asset that produces some kind of income or capital return. So Section 3.1 says that a trustee could make any kind of investment that he could make if he were absolutely entitled, and that's really what's been alluded to in the foregoing. And Section 4.1, although the Act doesn't define investment as such, refers trustees to the standard investment criteria with a focus on income and growing capital. The standard investment criteria are contained in Section 4, subsection 3, and they refer trustees to consider the suitability to the trust of investments of the same kind as any particular investment proposed to be made or retained, and of that particular investment as an investment of that kind, first and foremost. Sounds very convoluted, but in essence it's saying that trustees should consider the suitability of the type of investment first and foremost, i.e. should it be in some form of securities or some form of shares, and then the specific example of that type of investment. So if we've decided upon shares, should we get shares in Tesco? Or should we get shares in Asda? Or should we get shares in another company? Then, second to that, all trustees also need to consider the need for diversification of investments of the trust, insofar as is appropriate to the circumstances of the trust. This is standard investment practice. In other words, diversify your portfolio. Don't put all of your eggs in one basket. If you're going to invest in shares, don't invest entirely in shares in a single company. Spread the investment as broadly as possible, as is appropriate to the size and the circumstances of the trust. So the circumstances do have to be borne in mind, and for example in some trusts there will be a need to balance the needs of remainder men, as with the life tenant. And in other trusts, that's not necessarily the case, but there may also be a need to consider the available pool of resources to the trust. Is it possible to spread the investment widely or not? It may well be that it's not appropriate given the amount of resource available to invest too widely. But the investment criteria broadly are there to be focusing on protecting the trust as far as possible to stop any loss being incurred and to grow the trust as much as possible for the future. Section 4.2 provides that a trustee must from time to time review the investments of the trust and consider whether, having regard to the standard investment criteria on the previous slide, they should be varied. And this put into statutory form the previously existing common law position on the need to review investments. Trustees have got a clear duty to act in the best interests of beneficiaries. Unfortunately, many trustees historically believed that the best method of protecting the interests was to protect the capital. They therefore invested in low risk, low income areas which perversely actually disadvantage beneficiaries over the long term. Trustees, however, are not only required to consider the interests of their life tenants, but also those of the remainder men. And this apparent conflict, coupled with restrictive investment options, has left professional trustees caught between a rock and a hard place and resulted in a number of high profile cases. Now, the Trustees Act 2000, or rather Trustee Act 2000 should I say, has given professional trustees far greater investment freedom whilst making them more accountable. In addition, trustees are now also required to seek investment advice. And this is contained in section 5, where it says, before exercising any power of investment, a trustee must obtain and consider proper advice about the way in which, having regard to the standard investment criteria, the power should be exercised, and similarly when reviewing investments. So this requirement does not apply where the trustee reasonably concludes that in all the circumstances it's unnecessary or inappropriate to do so. Prior to the Act, trustees were required to take investment advice from someone they reasonably believed to be qualified to give such advice. The provision in the Act, however, as can be seen, states that trustees must obtain and consider proper advice about how to exercise the power of investment or how to review such investments. And it should be noted that this potentially covers all investments, including safe ones, such as national savings. So Section 5 puts into statutory form the common law position and states that advice must be given by someone the trustees reasonably believe to be qualified to give it by his ability and practical experience of financial and other matters relating to the proposed investment. Clearly, this clause is intended to cover the usual financial investment advisor, but also the qualities of someone who may be qualified to advise on things like land purchases or other more specialised forms of investment. An interesting point to note from section 7 is that the general rule is that the Act applies to all trusts irrespective of when they were created. There are some limited exceptions listed on the slide, but it is retroactive, so it widens the power of investment for trusts which came into existence before the Act was commenced. Previously, the purchase of land as an investment wasn't allowed, and this provision caused hardship when the beneficiary may have been in need of a residence for occupation. But through the Trustee Act 2000 at Part 3, the power to acquire freehold or leasehold land was granted through Section 8, and land can now be purchased as an investment, or as a residence, or for any other reason. So the Trustee Act 2000 has codified some of what has been seen in case law, but has also modernised the investment powers and broadened these out to cover the ever-changing circumstances of investment practice and to address problems that have emerged through cases such as hardship to beneficiaries. That concludes the second part of our podcasted lecture. In the next part, we will consider the fiduciary nature of trusteeship in particular detail. Hello and welcome to this, the third part of our podcasted lecture on administration of trusts. In part 2, we were considering generally the extent of duties in terms of the statutory duties and the duty of care. that trustees may owe to their beneficiaries. We'll now move on in this part to consider the fiduciary position of trustees. Why is it necessary to have so-called fiduciary duties? Well, trustees are in a position of power and authority, a position of trust and confidence, and that office is potentially open to abuse. So to prevent that from happening, equity classifies the relationship as one which is fiduciary in nature. It's one which puts duty at the heart of everything. But let's just take a moment to think about the concept of duty coming before all. So before moving on to look at the fiduciary concept in detail, let's provide a little bit of context. Fiduciary positions are connected with a binding sense of duty as the utmost consideration. And it's an interesting concept, a slave of duty or a slave to duty, one which has got a firm and long established tradition in our history and in our culture. Going out on a little bit of a limb here, but bear with me, some of you may have heard of Gilbert and Sullivan. Furthermore, some of you may even be fans of Gilbert and Sullivan. But as a partnership, they composed light operas, the forerunner to the modern musical. I'll explain the picture in a moment, but yes, that is me. Going back to Gilbert and Sullivan, in his early life, the lyricist of the partnership, Gilbert, received a liberal education, worked unhappily as a civil servant, studied and practiced law, unsuccessfully by all accounts, before finally moving on to form a collaborative partnership with Sullivan. But it's the civil service rather than the law routes which are interesting. Gilbert hated his time in the civil service and was disgruntled, but yet simultaneously frustrated and fascinated by its foundation on an almost thankless servitude and an idea of putting your duty to others first. And it's a recurring theme in the works of G&S. I said I'd explain the slide. Some of you may know already, but I do from time to time take part in some amateur dramatics and musical theatre specifically. I played the part of Frederick in The Pirates of Penzance in October 2007, and that explains the photograph. Pirates is a Gilbert and Sullivan show. I'll explain the concept because having done it, and in retrospect, it's actually a good illustration of the fiduciary concept. So, it's a musical comedy. The show starts with what we see as the 21st birthday of the protagonist, Frederick. Yes, that means I was the leading man. It starts on a pirate ship, and Frederick has come of age. He's 21. He served his pirate apprenticeship. Now, the apprenticeship itself was a mistake. His nursery maid misunderstood his father's instructions, saying you should apprentice Frederick to a pilot, and she misheard that as pirate. Now, Frederick hates piracy. He considers it immoral, but he served his apprenticeship all the way through its terms out of a sense of duty. Now that he's free to go, he decides he will leave. So he does, he leaves, and he goes on land, where almost immediately he meets a bevy of beautiful young maidens. These are the daughters of a Major General, as in, I am the very model of a modern Major General. And he falls in love with one of them, Mabel. Now the pirates then show up on land a short time later, and they want to have their wicked way with the girls. But just in time, their father, the Major General, shows up, and knowing the pirate code, he tells them that he's an orphan. Now, pirates take pity on orphans, and so wouldn't steal his daughters, so they let him and his daughters go. Frederick's aware that the Major General, his prospective father-in-law, has lied, that he's an orphan, but is glad to be free of the pirates, and he and Mabel become an item. Sometime later, the Pirate King shows up to see Frederick, and informs him that the pirates were missing him, and in reminiscing about the old times, they stumbled on something of a startling revelation. Frederick was born on the 29th of February in a leap year. Now, this means that although he's lived for 21 years, if you calculate by birthdays, he's only 5 1/4, because the 29th of February obviously only happens once every 4 years. And Frederick doesn't realise the significance of this, saying he was apprenticed to the pirates until his 21st year, but the Pirate King points out that it was until his 21st birthday, not year, meaning that in order to get to his 21st, 29th of February, he would need to serve another 63 years, technically, and be 84 years old before it's his 21st birthday. Frederick, being the slave of duty and having such a strong sense that he's bound to act in fulfilment of that duty, reluctantly agrees to rejoin the pirate band and also feels compelled out of duty to inform them of the Major General's deception. The Pirate King's enraged and plots to kill him and steal his daughters that night. In the end, though, by some complete nonsensical farce, it all turns out alright. The pirates are really noble men, and they still get the girls. The Major General's life is spared, and Frederick and Mabel live happily ever after. Now, you may question the relevance of all of this, so here it is. Frederick, and in general the Gilbert and Sullivan shows, are a prime example of this traditional, somewhat quirky and quaint and peculiarly English notion of duty that Gilbert observed through the culture of the civil service. The notion of your duty to serve the interests of others ahead of any concerns for yourself. And it's that notion that's the basis for fiduciaries. Frederick is the slave of duty, and a fiduciary is similarly a slave of duty. They will always put their duty above considerations for themselves and their own personal interest, and that is what is expected. So trustees are in truth an example of a fiduciary relationship. But why is it necessary to have these fiduciary duties? Well, as alluded to earlier, trustees are in a position of confidence and trust, and as such, the office of trusteeship offers tremendous scope for abuse. In order to prevent that from happening, equity classifies the relationship as fiduciary in nature. So a fiduciary relationship arises wherever X owes a duty to act in the interests of Y, and where X has rights and powers that could be exercised in his own interest to the detriment of Y. A number of examples are listed on the slide of fiduciary relationships, trustee and beneficiary being obviously the principal one for our purposes, but also directors and their company, solicitor and client, principal and agent, partners in business together. The examples on the slide aren't intended to be an exhaustive list, but they are good illustrations of a fiduciary relationship. The vague definition of fiduciary relationships has led the courts to try to expand the concept to cover an ever-increasing range of situations. There are two reasons for expanding the concept. Firstly, fiduciary duties are useful to fill the gaps that are left by the common law. The second reason is that it makes equitable remedies available, and these are generally more generous than those offered by the common law. Turning then specifically to consider the fiduciary nature of trusteeship, we've just established that the nature of trustee duty towards a beneficiary is fiduciary. A distinguishing feature of a fiduciary relationship is that the fiduciary is expected to act impartially in the interests of their principal. On the slide, I've set out the general principles which come from the case of Bray and Ford. And Lord Herschel in that case said, "It is an inflexible rule of a court of equity that a person in a fiduciary position is not, unless otherwise expressly provided, entitled to make a profit. He is not allowed to put himself in a position where his interest and his duty conflict. Therefore, very much like Frederick in the Pirates of Penzance, a trustee is a slave to duty, and they cannot have any personal interest. They must relegate their personal interest and consider duty to be the utmost first and foremost consideration." The rationale isn't strictly based on morality as such, but rather, as Lord Herschel himself put it, as based on the consideration that human nature being what it is, there is danger in such circumstances of the person holding a fiduciary position being swayed by interest rather than by duty, and thus prejudicing those whom he was bound to protect. This principle of no conflict, which comes from the case of Bray and Ford, has a number of potential applications and a number of different examples of it in practice. The first of these which we'll consider will be the self-dealing rule. Now, here, the rule is that if a trustee sells the trust property to him or herself, the sale is voidable by any beneficiary, no matter how fair the transaction is. So if a trustee decides that they want to purchase one of the trust assets for themselves personally, then a beneficiary can set that transaction aside, even if that transaction is fair. Essentially, the rationale is that because trustees are acting as vendor for the trust and purchaser for themselves, they place themselves in an obvious conflict of interest, and it's impossible to determine whether they've served the beneficiary's interests properly in securing the best price for them. There are some limited exceptions. The first of these is beneficiary's consent. This is unlikely to be taken lightly, and in any event, a beneficiary is presumed to be subject to the undue influence of their trustee, and so accordingly, it is highly unlikely that a beneficiary will have been considered to have consented validly they will not have entered into any transaction of their own free will. The second possible exception is authorisation in the trust instrument. Naturally, if a settlor has indicated that this arrangement would be okay, then the courts will allow that to stand. The third possible exception would be the court's consent, although the court, again, does not like to depart from the principle of no conflict at all. Although, on this particular point, the case of Holder and Holder in 1968 is an example of where the court may provide consent. Here, the Court of Appeal decided that it might be possible for a court to inquire into the trustee's knowledge and intentions, and to decide on that basis that it's permissible for transactions that are entered into in good faith to be affirmed by the court, rather than through being voidable, although Holder and Holder is an exceptional case. The fourth and final exception is where a trustee may have entered into a contract to buy the trust property before they became a trustee. If they were already in the process of purchasing trust property, then they will be allowed to continue to do so. But otherwise, the general rule is applied very, very strictly indeed, and a trustee cannot purchase trust property for themselves. A second example of this no conflict principle in operation is the fair dealing rule, and here the rule states that if a trustee purchases the beneficial interest of any of his or her beneficiaries, the transaction isn't voidable but can still be set aside by the beneficiary unless the trustee can show that he or she has taken no advantage of their position and has made full disclosure to the beneficiary that the transaction is fair and honest. Now the rule here is less harsh for the simple reason that the danger is less. There are two real parties to the transaction with their own interests at stake, unlike in the self-dealing situation where the trustee is purchasing from themselves, or rather selling to themselves. The bargain here is much more likely to be a real one. To prevent the beneficiary from avoiding the trustee's purchase of the beneficial interest in the future, trustees need to ensure that they disclose all material facts to the beneficiary before the purchase. They need to make sure that the transaction is fair and honest, therefore it's for a fair price, and they need to show that they took no advantage and that the beneficiary exercised independent judgment and was not the subject of undue influence. So here, directing beneficiaries to seek independent legal advice would be one such example. Given the general rule from Bray and Ford that fiduciaries mustn't profit from their position or put themselves into a position of conflict with their duties, how far does this extend to incidental profits? Well, we're going to consider the cases on the slide to investigate this further. And perhaps a fairly extreme example of the no profit, no conflict rule is in the case of Keach and Sanford. Here, the trustee held a lease for a minor beneficiary which he sought to renew, and the lessor refused to renew in favour of the minor. So, thinking there'd be no problem, as the beneficiary couldn't take the lease, the trustee took the lease for his own benefit instead. And it was held in the case that the trustee had to hold the lease on a constructive trust for the beneficiary because he put himself in a position where his personal interest and his duty conflicted, by being swayed by some personal interest. Lord King accepted that the consequence of the rule's application was the trustee being the only person of all mankind who might not have the lease, saying, but it's proper that the rule be strictly pursued and not in the least relaxed, for it's very obvious what would be the consequences of letting trustees have the lease on refusal to renew to the beneficiary. Normally, it's said that a fiduciary is liable to account for any unauthorised profits, which they receive as a result of their fiduciary position. But what does that term mean? If a trustee received an authorised profit, he or she will be made liable to account for that. That is, he or she will be required to bring the profit into account as an accrual to the trust. In this way, the right to demand the taking into account is the beneficiary's remedy against the fiduciary who makes an unauthorised profit, and in truth is what happened with the lease in this case. An even more extreme example of the no conflict principle in operation comes in the case of Boardman and Phipps. Now here, a trust had a significant holding in a failing company, and one of the beneficiaries concerned about this spoke with the trust solicitor, and they decided that they would try and save this failing company. And so what they did was they bought shares with their own money, and this enabled them to combine their personal shares with those of the trust to take a controlling interest in the company. And they appointed themselves directors and took charge of the company. And as a result, they were able to sell off some of the company assets, paying out large dividends, while at the same time maintaining a high share price. So they turned around the fortunes of the company and helped the trust. But another beneficiary became jealous and sued Boardman and Phipps, calling upon them to account for their profits that they'd earned on the shares that they purchased with their own money, saying that these were profits that they acquired in breach of fiduciary duties to the trust, acquired in conflict with the trust. And the House of Lords held by a 3-2 majority that Boardman and Phipps were liable to account for the profits they earned. This was on the basis, in essence, that they'd acted in conflict of interest. Now, Lord Guest did this on the basis that Boardman's liability was based on use of information obtained in the course of his fiduciary position. But Lord Guest's formulation here doesn't take account of the fact that Phipps was a beneficiary and wasn't in a fiduciary position, and also that the other trustees consented to them doing this. But Lord Hodson agreed with him on. Lord Cohen didn't go down the same route as the other two judges in the majority, and instead he based it more on the clear conflict between the interest and the duty, saying that Boardman would have been unable to give impartial advice if asked, because he put some of his own personal money up front. He would be swayed by his personal interest rather than by his duty. This is irrespective of the fact that the actions of Boardman and Phipps together had actually benefited the trust. Now, Lord Upjohn wasn't happy with the majority view, and he dissented, saying that the no conflict rule shouldn't be applied in all circumstances. It shouldn't be applied automatically. And for him, liability needed, firstly, an unauthorised profit, but secondly, a real sensible possibility of conflict. And in his view, because they were acting in the interest of the trust at the same time as the interest of themselves, the two things weren't in conflict with each other. They were compatible with each other. Note, Lord Upjohn was, however, in the minority, and so his decision didn't stand. But also note that in respect of company directors, who you may recall from earlier are also fiduciaries, the Companies Act 2006, as section 175, has actually given statutory footing to Lord Upjohn's dissenting judgment. But this only applies in relation to company directors and not to other fiduciaries such as trustees. So Boardman and Phipps, as harsh as it is the principle that we have to stick with in relation to trust. As further examples of a no conflict principle in operation comes the case of Reed Thompson, and in that case an executor was restrained from carrying out a yacht brokering business themselves personally, because that would have put them in competition with the estate for which they were a trustee. So a trustee or other fiduciary must not put themselves into a position where their duties as trustee and their own interests conflict by becoming a business competitor. And further, in Re McAdam, trustees use their position to appoint themselves the directorships of a company, and they were held liable to account to the trust for all the fees they received as directors. So as you will have noted from Boardman and Phipps, this rule applies to other fiduciaries, for example solicitors and company directors. Note the principles here we're looking at only apply where there is a fiduciary relationship between the parties. It cannot apply where there is no such relationship. But wherever there is a fiduciary relationship, this conflict of interest principle is adhered to quite strictly indeed. Finally, on the issue of fiduciaries and the extent of their duties, comes to the case of Regal Hastings and Gulliver. Now, this was the leading case applying the no conflict principle to company directors. Obviously, this has now been superseded by section 175 of the Companies Act. But as a general statement of principle on fiduciaries, it is still useful. In the case itself, Regal, the company, were considering applying for shares in a subsidiary company, but were unable to afford the total price. So the directors subscribed themselves to the tune of £500 each and made a profit when later selling them. Now, the directors wouldn't have been in a position to profit had they not been directors. Arguably, there was no conflict of interest, given that Regal, the company, were not in a position to subscribe for themselves, yet the directors were still held liable to account. And it was pointed out by Lord Russell that this was the correct approach, saying that the rule of equity, which insists on those who, by use of the fiduciary position, make a profit, being liable to account for that profit, in no way depends on fraud. The liability arises from the mere fact of a profit having been made. The profiteer, however honest or well-intentioned, cannot escape the risk of being called to account. And it is that line of thinking, that line of reasoning, which underpins the decision in Boardman and Phipps, the majority decision in Boardman and Phipps, that it doesn't matter about intentions. It doesn't matter if intentions are good at all. If there is any possibility of a conflict of interest and any profit having been made, then the fiduciary will be held liable to account. So in the context of trustees, this principle still stands. Given the extensive duties then of trustees and the tight controls on the fiduciary office, is it really ever worth being a trustee? Is it all work and no pay? Well, the basic rule is on the slide. Trustees cannot charge remuneration. They have to administer the trust free of charge. This rule applies to trustees and to personal representatives. Of course, as you'd expect, it doesn't extend to other fiduciaries such as company directors or solicitors. But the rule's based on the general principle from Bray and Ford that a trustee mustn't gain any financial benefit from the trust property nor make any secret profit. So the reason for this really is that first, trustees mustn't be tempted to undertake unnecessary work for the trust knowing that they've received payment. We'll do some extra work that's not even needed so I get paid more. And secondly, as the trustees would determine the amount of remuneration, that itself produces a conflict of interest. And thirdly and finally, people aren't compelled to become a trustee. You can refuse from the outset, and a professional who doesn't wish to take an unpaid appointment can always disclaim. Having said that, as I'm sure you're now accustomed to, with almost every rule there are exceptions. Trustees can charge fees if there is a clause authorising remuneration in the trust instrument, and it's common for wills and trust documents to contain these charging clauses. Secondly, where the beneficiaries are sui juris and have entered into a contract for remuneration, this will also be allowed. In relation to this second exception, it's presumed that in negotiating such an agreement, the beneficiaries are subject to the undue influence of the trustees, and unless the agreement is fair, then the beneficiaries can potentially set it aside later. The court also has an inherent jurisdiction, but the power used to be exercised sparingly. Nowadays, in the light of Reid Duke of Norfolk settlement case, the courts may be more generous to trustees. Lord Justice Fox said that the courts must balance the need to protect beneficiaries against trustees' claims versus the effective administration of the trust. And the court should order remuneration if it's in the interest of the beneficiaries because, for example, the trust needs the skill of the trustee in question and his fees aren't excessive compared with other professionals. Finally, the rule prohibiting remuneration was considered to be largely out of date, and in 1999 the Law Commission recommended that the law should permit professional trustees to charge fees, and the relevant provisions were included in the Trustee Act, which we all know. Section 29 of the Trustee Act provides that trustees who act in a professional capacity are entitled to recover remuneration. The section before, subsection 5, provides that trustees act in a professional capacity where they act in the course of a profession or business which consists of or includes the administration of trusts or particular types of trust or particular aspects of such administration. Note that by virtue of section 29, subsection 5, trustees can't rely on this section if any provision is made in the trust instrument about remuneration. In terms of determining the level, Section 29, subsection 3 states, in relation to the provision of services by a trustee, such remuneration as is reasonable in the circumstances for the provision of those services to or on behalf of the trust by the trustee is what should be allowed. So when determining what's reasonable, section 29.3 requires us to consider the nature of the services, i.e. are they very specialist, the trust, is it a small trust, and the attributes of the trustee who's seeking to charge. Is the trustee the most appropriate person to provide the services, or is it better to use an agent? Might the trustee even be expected to provide the services free of charge? And as long as you consider all those things, then the trustee acting in a professional capacity can claim reasonable remuneration. Note one final point in this area: trustees have always been entitled to be reimbursed for out-of-pocket expenses. and Section 31, subsection 1 of the Act puts that on a statutory footing. That concludes the third part of our podcasted lecture. In the fourth part, we'll consider whether it's ever possible for trustees to lighten the load at all and delegate. And finally, we'll look at powers of trustees. Hello and welcome to the fourth and final section of our podcasted lecture on administration of trusts. In the previous part, we've looked at the fiduciary nature of the trust relationship and considered the duties of trustees. And we've discovered that trustees may potentially be paid for the work that they do, but given the onerous nature of trusteeship, is it ever possible to lighten the load at all? Is it ever possible to pass on some responsibility to anyone else? Now, the classic statement of the position is in the maxim, delegatus non potest delegare. The person to whom responsibility has been delegated may not delegate that responsibility to another, i.e. a delegate may not delegate. In other words, a trustee has to provide a personal service to the trust. The rationale is that a trustee is personally liable in conscience for all of his own acts and defaults under the general law of trusts. In the seminal text Farwell on Powers, though, the authors assert that in fact, strictly speaking, the rule only ever prohibited the delegation of a trustee's fiduciary powers, and doesn't prohibit the delegation by them of obligations to do acts merely ministerial. In relation to the delegation of fiduciary powers and duties, the position was summarised by Viscount Radcliffe in the House of Lords in Pilkington. The law is not that a trustee cannot delegate, it's that a trustee cannot delegate unless they have authority to do so. In terms of finding where that authority might come from, then authority to delegate under the general law can now be found in a number of statutory provisions. Authority might also be expressly granted by a clause in the trust instrument, or upon an application to the court for an extension of the trustee's power of delegation. But what if there is no power within the instrument? The basic rule, as we just saw, was that a person entrusted with a fiduciary duty doesn't fulfil it if he delegates it to someone else. He remains liable for the other person's default. But this rule was never, even in the times when the most rigorous views were being taken of the standard of conduct required of trustees, was never inflexible. Indeed, there are certain things which a business person would always delegate to a skilled agent. Thus, the employment of solicitors for legal duties and brokers and bankers for financial matters is considered to be ordinary business practice, and this has been recognised for a long time. So where things are done as agents in the course of a business ordinarily, then that would be acceptable. In June 1997, the Law Commission published their consultation paper on trustees and their powers and duties, and a number of issues were looked at, including trustees' collective powers to delegate. Their main proposals with regard to delegation are on the slide. That is, trustees should have authority to delegate their powers to administer the trust, including investment and management, but should not be allowed to delegate their powers to distribute capital or income. The recommendations were prompted in the main by the increasingly complex range of investment opportunities available, by major changes in share dealing and settlement mechanisms on the stock exchange, and the introduction in 1996 of the CREST system, which is a computer-based system for the electronic transfer of and settlement of trades in securities. However, we can see from the Trustee Act 2000 that statutory authority has indeed been given to most of their recommendations. Clauses 11 to 15 of the 2000 Act set out the powers of trustees to delegate their functions, and Section 11.1 states that trustees of a trust may authorise any person to exercise any or all of their delegable functions as their agent. And Section 11.2 defines what are delegable functions. Note, these provisions apply to what is sometimes referred to as collective delegation, meaning that all the trustees acting together appoint an agent to carry out some function. This can be contrasted with individual delegation, where one trustee delegates all of his functions to another person, which can be done by power of attorney. More on that in a little while. But staying with collective delegation, the 2000 Act's powers are only to operate if there are no express provisions in the instrument. The only functions which cannot be delegated are listed on the next slide. And the non-delegable functions are a function relating to the distribution of the trust assets, a power to allocate fees or other payment to capital or income, a power to appoint trustees, and a power conferred by the trust instrument or an act permitting trustees to delegate any of their functions or to appoint a nominee or custodian. So this changed the basic law that had forbidden trustees from delegating fiduciary functions, such as the selection of trustee investments, and it had long been considered that these rules were out of date. Trusts have become increasingly complicated, as indeed have investments generally, and many trustees need to be able to delegate in these circumstances. So this newer law differentiates between the non-delegable powers on the slide and delegable powers like the power to choose investments. Under the Act, apart from beneficiaries, anybody can be an agent. This is subject to the rule that where the appointment is made jointly, the agents must exercise their functions jointly. An agent appointed under the 2000 Act will be subject to any restrictions attached to the trust, but they're not subject to the duty of care under Section 1 of the Act. Rather, instead, they owe a duty of care to the trustees under the general law. In terms of the liability of a trustee for any actions of agents or third parties that are appointed, then the 2000 Act now makes the law clear, and Section 23(1) states that a trustee is not liable for any act or default of the agent, nominee or custodian unless he has failed to comply with the duty of care applicable to him. In other words, as long as the trustee complies with the general duty of care and fulfills his function of review, then he won't be personally liable. That means that a trustee who takes the appropriate care in the selection of his agent and carries out review requirements won't face personal liability if the agent then does something which causes a loss to the trust fund. That seems only reasonable for a non-professional trustee, but a paid professional trustee would have to exercise a higher duty of care to avoid liability. What we've been dealing with on the previous slides is generally termed as collective delegation. Individual delegation is where a single trustee decides to delegate all of their functions, including dispositive functions and other fiduciary functions, to someone else using a power of attorney. Now, this used to only apply where someone was outside of the UK for an extended period, but can now be done for various other reasons due to various amendments in legislation. But the provision by which a trustee can delegate is authorised in Section 25 of the Trustee Act 1925. The thing to note here is that liability for individual delegation is very different to liability for collective delegation. There is no protection where a trustee delegates under Section 25. Under Section 25, the donor of the power of attorney will be liable for the actions of the donee as if they were their own, i.e. he or she will be vicariously liable for the defaults of those to whom the power has been delegated. So, if you are a trustee and you choose to have a little bit of a long holiday, sabbatical for whatever reason, be careful in whom you select to delegate your functions, as you remain liable for any of their actions. The final section of our discussions on administration of trusts is around powers. We have in fact encountered some powers previously, for example powers of appointment when referring to the distinction between those and discretionary trusts, and we've already considered the nature of power versus the nature of a trust duty. We're going to consider a couple of specific powers that can be useful in a number of different circumstances. When are these particular powers useful? Well, a beneficiary might not be entitled to the capital of the trust until some future time. For example, as stated on the slide, for Yasmin, even when she attains 25. Yasmin won't receive the capital of the trust unless and until she satisfies the contingency of reaching 25. However, Yasmin may, as the beneficiary of the trust, need money in the meantime to pay for her maintenance and education, or she may also need a capital sum to buy a house or set herself up in business before reaching 25. So there are certain powers which could be useful in these circumstances to help Yasmin. The two main powers we're considering here then are the statutory powers of maintenance and advancement, and these are often considered together with good reason, as they're very closely related. The real difference under the powers isn't for what purposes money can be allocated, because both are worded widely in terms of the powers, and both also contain the word benefit, but the real distinction is where the funds come from. In relation to the power to maintain, the power of maintenance enables a trustee to spend income from the trust, but not to pull any capital out of the trust, and it's generally for the benefit of infant beneficiaries. It can be expressly provided for in the trust instrument, but in other cases there is a statutory power contained in section 31 of the Trustee Act. So section 31 and the power of maintenance are concerned with trust income. So as you're aware, the trust fund usually comprises income producing assets, authorised investments. So for example, it could include company shares which produce income by way of dividends, bank and building society accounts which yield income in the form of interest, and land which could produce rental income. Let's take a look at this. Section 31 states that trustees may, at their sole discretion, pay to an infant beneficiary's parent or guardian, if any, or otherwise apply for or towards his maintenance, education or benefit, the whole or such part of the income of that property as may be reasonable. And this applies whether or not the infant's interest is vested or contingent, but the trustees have to have regard to the age of the infant and his requirements, and generally to the circumstances of his case, and in particular any other income which could be available for the same purposes. Note when the beneficiary attains the age of 18, if they're still in need of maintaining for education and so on, then the payment is made directly to the beneficiary. The power of advancement is slightly different to the power of maintenance, as it applies to capital under the trust and relates to the possibility of trustees deciding to allow part of the trust capital to be paid out or used for the benefit of a beneficiary before their entitlement to the fund becomes vested. The power again can be expressly provided for in the trust instrument, but otherwise there is a statutory general power in section 32. So the power is useful when beneficiaries need trust capital earlier than they are strictly entitled to it under the trust. The term advancement doesn't mean it's a loan, it's a way of releasing part of the beneficiary's entitlement to trust capital early. Again, the section applies to vested and contingent interests, provided that the money paid should not exceed 1/2 of the shares of that person in the trust property. And of course, any advancement has to be set against the eventual entitlement of the beneficiary. In other words, you can't claim twice. There is also a further proviso to section 32, in that no such payment or application shall be made as to prejudice any person entitled to any prior, life or other interest in the money paid or applied, unless such person is in existence and of full age and consent in writing. So, the maximum that can currently be advanced is 1/2 of the beneficiary's entitlement, and the beneficiary must bring any advancement into account on becoming absolutely entitled. That is, any advancement would be offset against their eventual entitlement. And anyone with a prior interest in the money paid or applied has to be an adult and therefore consent in writing to the advancement. Often advancement follows requests from beneficiaries, or in the case of infant beneficiaries, from their parents. But to what extent are the trustees under any duty to oversee the use of the funds that are advanced to ensure that they're actually used for the purposes for which the advance is actually made? And trustees are free to become involved, in fact, and to pay money not to the beneficiary, but to others in order to advance or benefit. But of course it is also open to them to pay money to the beneficiary so that he or she will then have control of the money. What extent then should trustees follow up to make sure that the money is used properly? Well, on that point, see the case of repooling settlement trusts. In this case, the trustees had an express power of advancement under a marriage settlement to advance to the children of the couple. And the trustees advanced money nominally to the children, but it was used to benefit the family as a whole. In each case, the consent of the wife was obtained according to the requirements of the express power, and the children were full age and never objected to the way in which the advancement was used. But the Court of Appeal held that the power had been improperly exercised. So where the trustees exercise a power of advancement, they can make either an out payment for the general benefit of the beneficiary, if they trust them, or make a payment for a particular purpose. And the court was saying in this case that they ought not to have made the payments because they weren't used for the purpose that had been specified. The Court of Appeal said in repoolings that the trustees must not leave the beneficiary entirely free, legally and morally, to spend the money as he chooses. If the money was advanced for a particular purpose, the beneficiary is under a duty to use it for that purpose. If he does not, and the trustees know, it would be unsafe for the trustees to make further advances unless the trustees are sure that the money would be correctly used. Note, in relation to all of these powers, maintenance and advancement, there are changes soon to be enacted to both the powers of maintenance and advancement. The Inheritance and Trustees Powers Bill is currently making its way through Parliament, slowly by all accounts, but under the new proposals, trustees' powers to advance assets to beneficiaries are to be extended. Currently, the Act allows trustees to pay out up to one half of the beneficiaries' prospective capital share in a trust before they're absolutely entitled. But under the reforms, the power will be extended so they can advance up to all of it, 100% of the beneficiary's share. Additionally, trustees will no longer be restricted to paying out cash to a beneficiary, but will have the power to advance or transfer other assets instead, such as shares or property. And that puts the existing case law in this area on a statutory footing. So that's administration of trusts, and it is quite a broad area. But we looked at the nature of trusteeship and seen how trustees are appointed. We've seen the various mechanisms and methods for retirement, removal and control of trustees. We've established that the office of trustee is onerous and that it's not a position that should be undertaken lightly. And we've looked at the issue of delegation before finally considering the powers of maintenance and advancement. As noted at the very start of the first part of this podcasted lecture, this ties in very well then with the next topic around breach, liability and remedies, and looking to the consequences that attach to a trustee not adhering to the strict duties that are expected of them.